And moving on, the vigor for constitutional amendments through the Building Bridges initiative, that is BBI, has already taken a contested trajectory after a section of political leaders, religious leaders and civil society groups expressed their opposition to the changes. What was deemed to be a civil society group terming the 2020 constitutional amendment a state project and illegal, since the constitution only provides for only two processes of initiating its amendment: popular and parliamentary initiative.
Kuru Court last year flopped after his Punguza Mizigo bill failed to garner the support of a minimum 24 counties, with more than 30 counties rejecting it. The Building Bridges initiative, spearheaded by President Uhuru Kenyatta and opposition chief Raila Odinga, is now awaiting the verdict of the Independent Electoral and Boundaries Commission (IEBC), which was presented with more than 4 million signatures in support of the referendum to verify.
Today, we are presenting the signature with the bill. And it's important for us to say kwamba this is the same bill ambaye we launched the signature correction on 28th in KICC.
It's already available. We have a referendum committee which will undertake the exercise of signature verification. But of course, we shall not commence until we get a budget and exchequer from the National Treasury.
According to President Kenyatta and Odinga, the BBI is intended to cure fissures from divisive politics that manifest every 5 years due to disputed electoral outcomes.
Na tukaona ya kwamba hii ni shida ambaye kila wakati ambapo tuko na uchaguzi, badala ya kutoka kwa huo uchaguzi wa Kenya wakiwa pamoja, mara nyingi tuamaliza uchaguzi wa Kenya wakiwa wamegawanyika.
So that each and every child born in our country, irrespective of their socio-economic status, has equal opportunity to realize their God-given abilities. That all our people can live peacefully. They can access health care irrespective of their financial status.
Chapter 16, Article 255 of the Kenyan Constitution states that the country's supreme law can be amended through a referendum if any changes relates to either the supremacy of the Constitution, territory of Kenya, sovereignty of the people, national values and principles of governance, Bill of Rights, the term of office of the President, judiciary functions, object and principle and structure of devolved governance, among others.
The Constitution has a Puritan and puristic approach to issues. If it is the people to say they are amending the Constitution, the people are to say they are amending the Constitution through a referendum of the people. That's a popular vote. Then if it is Parliament that has been given powers, Parliament must do its work because the Constitution says so, has donated that power. And if Parliament is to legislate so that certain things are done, are effected, and laws are enacted, Parliament has to do so.
There are many who question the intention of BBI because it appears to have overlooked the input of other stakeholders. Others feel the BBI report in its current state reflects a clawback on the separation of powers between the three arms of government.
Ni utapeli wa hali ya juu kwa viongozi wetu kujaribu kupitisha vitu ambavyo wanajua vizuri hazihusishi wa Kenya. Kwanza Mkenya wa kawaida.
That what BBI is attempting to do is actually to steal your present and your future.
I am concerned that what BBI proposes is an overhaul of our 2010 Constitution, not an amendment. Importantly, I am concerned that it is either deceptive or burdensome or both to require Kenyans to educate themselves on the pros and cons of so many changes that BBI proposes.
Kenya leader Martha Karua is questioning the BBI-led referendum process, saying a popular initiative shouldn't have come from the state nor organized using public resources.
People's initiative cannot come from the state, cannot be organized using public resources and using state machinery. In fact, we are of the view that this is a usurpation of a space the Constitution keeps for the people. We also think that it is a patently unconstitutional process by this very means.
It is extremely unprocedural for the state to purport to go to a popular initiative because they have the powers and privileges of office. They have the power and privileges of making legislation. And so, for them to use the popular initiative route is actually an abuse of process and power.
She insisted that if the state wanted to amend the constitution, it should have gone the parliamentary way.
He could have directed the Attorney General that, you know, for the purposes of this 9-point agenda, we are proposing constitutional amendment. Can you formulate a bill? And then we put it through Parliament. But you see, it would have been a more difficult process because in Parliament, they have to convince 2/3 of those members to vote. That is one. Two, there is the 90-day period within which all Kenyans can give their views. And some...
Lawyer Kithi further opines that the BBI architects could have separated the issues that could be amended through Parliament and those that need a popular initiative.
It would have been best if issues were separated. The power of the people under Article 1 to amend the Constitution and those issues that relate to a referendum, which is the popular vote, should be left to the popular vote. Those issues that are legislative in nature, pure legislative, where the Parliament can enact those issues, the laws through a legislative process, should be left to that. And those part of the articles or sections of the Constitution that ought to be amended by Parliament as power donated by the Constitution, still can be amended through that process.
As the BBI architects continue drumming up support for the document, a silent legal battle is being waged to stop the proposed amendment. At least 5 cases are pending before the Supreme Court and the High Court. In one of them, the initiative was government-sponsored and should not follow the popular initiative route to a referendum. Another case at the High Court wants the court to stop the process, arguing that Parliament should not pass laws that alter chapters on the executive, judiciary, which are core to the function of the country's constitution.
So to try and amend Article 1 or the very power of the people and the sovereign is actually creating a coup. So you can't have a coup of the Constitution itself. You can't. And therefore the very existence of the sovereign of people cannot be amended by itself. What can be amended are certain areas that have been identified by the Constitution. That which the Constitution has not identified as amendable, then cannot be amended.
We must ask ourselves, because what is the foundation of our Constitution? It is in Article 10. Inclusion, rule of law, democracy, sharing of devolution, all that, shared prosperity, all these things go to Article 10, the national values and principles of governance. That's the foundation of our Constitution. The minute you begin to tamper with that, then you begin to unravel the entire structure of our Constitution. So there are certain things like you can't do. You know.
At the Supreme Court, the Nandi and Kericho County Assemblies is seeking clarity on whether members of County Assemblies, MCAs, can amend the bill sent to them for approval. It is also here that Makueni Governor Kivuta Kibwana is seeking a ruling on the validity of national or county governments to steer a constitutional amendment through a popular initiative.
Whether the process undertaken this far through BBI has complied with the Constitution, and in this regard, whether in the future governments, both national and county, and public officers can rely on the resources and the authority of the state to generate constitutional change proposals through the popular initiative option.
Each of these litigants and critics may have plausible arguments whose handling could weigh heavily on the outcome of the initiative. Suleiman Yeri, Channel 1 News.